guys, welcome back to my channel. I hope you are all doing well and I hope you guys are enjoying this relationship series that we are currently doing on my channel. Don't forget to like, comment and subscribe, and let's get on to today's video. On the last two segments of this series, where I'm now speaking of the available systems of umshado. What are the available systems that you might actually get married into? So the marriage systems are regulated or governed by statutory provision, and the particular act which governs this is the Matrimonial Property Act 88 of 1984. This act says that there are three forms of marriage system, matrimonial property systems which are available. We are going to discuss these three right now. First system, and the most common system that is used by most married couples, and if you do not have an ANC contract, you are automatically considered as to be married in this system, is the system that is in community of property. That system is a system that if you and your bae decide this morning we are going to go and get married, and you do not consider going to a notary and actually trying to do an antenuptial contract, which I'll discuss in the further systems that I'm going to be speaking to you about, you are going to be automatically married in community of property. What does being married in community of property mean? In terms of section 15 of the Matrimonial Property Act 88, it says that the two estates of individual partners are joined together as one, and each party has now a right to dispose over every asset that is within the joint estate. And every asset includes your pension fund. So if you're employed and have a pension fund, that is included, and you've probably been employed for like 20 years before meeting your partner, that is included in your joint estate that you are now forming if you are married in community of property. And the thing is, you require consent for disposing of any asset. So if you want to sell a car, sell a house, sell whatever, you require consent. But with the consent aspect, you don't need written consent. But if somebody sold your car maybe, and you realize, no, I didn't give consent to that, you can dispute it, and that sale could actually be invalid based on the fact that you didn't get the particular consent that you needed in terms of the act. However, things like buying property, buying land or selling land require written consent. So there are certain aspects that need written consent. But the one place where you don't need consent from is if you are making proprietary decisions that relate to your business or whatever trade that you are doing. You don't need consent of your partner in that sense, but you actually have your partner actually has a share in your pension, which I think is one of the most flawed thing ever, but it is what it is, because that forms part of our assets wing. So the partner has all of the rights in equal share to you. You can't say because you're married in community of property you have 30% share, I have 70% share. No, they have equal share, unless you can prove to court, like for example, okay, now I'm getting into details of divorce law. In a divorce you can ask for forfeiture of benefits. That's a different video in its own. So yeah, anyways, by the way, this video does not constitute legal advice. If you are looking for legal advice, go and consult a registered legal practitioner. Marriages which are customary marriages are also considered to be marriages which are in community of property, but that only relates to marriages that are concluded after November 2000. If your marriage was concluded before that and you guys were married out of community of property, as the case is for people who are married in customary law and maybe married to more than one partner, their marriages are usually considered to be out of community of property. Then that's it if you were married before 2000, unless you guys say you want your marriage to be governed by by it being a joint estate. Another interesting thing to note about this form of a marriage system in community of property, if you have any claim for damages, for example, for bodily injury from your said spouse, though you guys are married in community of property and the damage happened while you are married in community of property, you have a claim and it does not form part of the joint estate. That's the only thing that does not form part of the joint estate. And things such as testamentary assets. Testamentary assets are those assets that we were given by will, maybe by your mother, who said specifically that they want those assets to be excluded from the joint estate. So wishes of somebody who is a testator will take precedence over logo, unless circumstances are different. So yeah, the best or the most ideal marriage system, which I think because it's based on the fact that we are equal partners and it's managed by partnership, it is ideal in my case, in my view. So there's an equal share of profits that are made during the time of umshado. Okay, that is the out of community of property with accrual. Here, anything that you guys make during umshado weni, during the time that the marriage subsists, whether at the time thereafter, at the time of dissolution of umshado, whether through death or divorce, you guys get to actually have equal share to the profits that are made. So we first determine estate law or onemali encane separately, and then nemali as your separate estate. So because here you can both start with zero assets in your ANC, the antenuptial contract, which is entered into if you are getting married out of community of property. You then state to how are you guys starting your estates? Are you guys starting your estates at 2,000 Rand each, or you starting them at nil? And then the amount of money that you guys have at that time, the one with the larger estate will then get half of the difference of the smaller estate. So here, say ushade, and you have assets that are more than low munye. What is then made in your ANC, you state the assets which you will exclude. So you may exclude assets such as inheritance, legacies, donations, anything that you want to exclude is excluded. And then once it's time for dissolution, all of the profits that are made, state values, are determined separately. So une estate yakho Asanda, une estate ya husband wami, and those two estate are then transferred. The larger estate must then transfer half of the difference to the smaller estates, so that we are then equal at the time of divorce. Akekho umuntu ozohamba nemali enkulu kunomunye. So hamba neimali zethu, but imali esifike nayo before, or whatever that we came with before, remains ours unless we said otherwise on the antenuptial contract before getting married. There you can say, Guti, you want to start your marriage at 0 or you want to start it at like 10. Okay, here you can actually go to court and apply for forfeiture of benefits. So the profit that is made in the marriage can be actually made an application in terms of Section 9 as you would apply for forfeiture in terms of section when the person is married out of community of property. So here, what we had before mshado, okay, remains ours, and then what you make here will then become ours, but whoever that has more of their assets will then get half the difference of the less of the one with the one who has less will get the difference after having equally divided le share. So if kukuthi uno 10 rand, lo munye uno 5 rand, and then there's 20 rand, which is here, the other one will not get 20 rand, will get 5 rand, then the 10 rand comes here, and then we are equal. I hope I'm making sense. If I'm not, go and consult if and you want to get married and want to get married out of community of property. The final type of marriage is out of community of property with the accrual expressly excluded. What does this mean? Okwami, okwakho. Ayihlangene emhlali. Noma ngabe kuthiwa kwenzakalani, you keep what's yours, I keep what's mine. That's the basic explanation of out of community of property without the accrual. Here it is also made by a notarial antinuptial contract, and where in that contract you have to expressly say that the profits and losses are excluded. However, there is juristic equality where you have rights to dispose over your own assets. So ama-assets ami ngingawenza noma yini without consenting you, without consulting you, and ama-assets akho nawe ungawenza noma yini without ever consulting me. And you're like, oh, you bought a car? Yes, I did, Malia. That's the kind of marriage that is with express exclusion of everything, profits or loss. But in terms of financial equality regarding the household necessities, again, you do not have equality here. What does it mean? It means that whatever that each spouse contributes, you cannot claim from them. Buti, you want your share of the estate simply because ubani mhlambe asike sithi ubaba la ekhaya kade ondle ngokuthi akhokhele umuzi, and then you go then and say you are claiming that money because bekadenza lokho. That's not the case unless you guys have a written agreement that owami imali izokuthenga ukudla eyakho uzothenga umuzi. Then in that sense you guys can actually claim part of the estate, but otherwise you have no share of the estate based on specifically that, unless the person dies interstate. But when the marriage is dissolved through divorce, you cannot make claims such as that. If your husband makes enough money, that is so like a lot of money, you do not have a claim based on it just because now and you say that, and then you claim if there was no food, he wouldn't have been able to make this amount of money. You can't make that claim simply because une rights to do whatever. Now if it goes, it goes. If it decreases, it decreases. It's basically but anyways, do whatever that you want and seek the proper legal advice. This is just legal information, and this thingy, I mean, this sort of marriage is actually a good type of marriage for people that have already built up their estate. So if you're getting married with a 70-year-old or 20, not built much of an estate, although some 20-year-olds are millionaires. But anyways, if there's that difference and you don't want to now start again and be in a situation of having to consult or whatever, you don't actually have to. It's actually recommended for people like that. But otherwise, I don't see it as an ideal relationship situation, but you do you, boo. I'm just giving you all the information. So I hope you guys enjoyed this video. And with that being said, this week talking about divorces. How then do we end all of this situation? We end it by this. How do we dissolve a marriage? We dissolve it by divorce. How do we do that? Our next video will be discussing just that. Hope you guys enjoyed this video. Don't forget to like, comment, and subscribe. Bye.